दोस्तों बहुत बहुत स्वागत करता हूं मैं राजेश कपूर आपका इस टिकटॉक्स के नए एपिसोड के अंदर। आपको ये सीरीज बहुत पसंद आ रही है, ऐसा आपकी मेल्स और आपके फोन कॉल्स हमें पता तो चल ही रहा है, लेकिन हमारी ये कोशिश भी जरूरी है कि हम लोग कुछ ना कुछ नया आपके साथ हर एपिसोड के अंदर डिस्कस करते रहें, तभी तो आपका प्यार और आपका स्नेह हमें मिलता रहेगा। इस एपिसोड के अंदर हमारी कोशिश रहेगी दोस्तों आपको डेटा प्रोटेक्शन बिल के बारे में विस्तार से कुछ बताने के लिए। हमारे साथ सेट के ऊपर मौजूद रहेंगे हमेशा की तरह डॉक्टर नवीन धाम, जो कि फाउंडर हैं GISPL के और एक बहुत ही बेहतरीन साइबर एक्सपर्ट है। डॉक्टर धाम, आपका बहुत बहुत स्वागत है हमारे शो में। बहुत ही फक्र के साथ मैं एक और गेस्ट से आपको रूबरू करा दूं। NA विजय शंकर बेंगलुरु से हमारे साथ जुड़ रहे हैं और दोस्तों उनको सभी लोग प्यार से नावी बुलाते हैं, तो हम इस शो के दौरान भी उन्हें इसी नाम से मुखातिब करने वाले हैं। उनके इंट्रोडक्शन के तौर पे मैं आपको बताना चाहूँ तो वो एक डेटा प्रोटेक्शन एंड डेटा गवर्नेंस कंसल्टेंट तो हैं ही, साथ ही में डायरेक्टर हैं FDPPI के, फाउंडेशन ऑफ डेटा प्रोटेक्शन प्रोफेशनल्स इन इंडिया के। तो दोस्तों आइए स्वागत कर लें नावी का। नावी, आपका बहुत बहुत स्वागत है हमारे इस शो में। सबसे पहले लेट्स बिगिन विद नोइंग अबाउट दिस बिल सर फ्रॉम यू। Can we have a little brief about it?
Yeah, good day to all of you, friends. It's indeed a privilege to be with you to discuss this very momentous kind of bill which we have seen in India, the Digital Personal Data Protection Bill 2023, which now becomes an act because it has been already passed by both the houses of Parliament. We will refer to it shortly as DPDPA, that is the act. Okay. So now, for the last several years, India has been trying to work out a particular legislation to provide some kind of protection to whatever was called as the right to privacy by the Supreme Court in one of its famous judgments called Puttaswamy judgment. Where it declared that right to privacy is a fundamental right under Article 21 of the Constitution, and the government should actually come out with some proper legislation to provide statutory protection to this right to privacy. Now, what the government has now done is they have brought out a legislation exclusively for this information privacy protection. That is why this is called Digital Personal Data Protection Act. People will immediately ask what happens to non-digital privacy protection. For that, of course, our existing laws are there, and therefore this particular act says this will be applicable only when personal data is collected in India in digital form, or if it is collected manually, if somebody inputs it into a computer, then it becomes digitized personal data. So this act will apply to those kind of situations. And what the act does is it actually puts certain obligations on the organizations which collect this data. In fact, these companies which collect the data are called data fiduciaries, and they are given certain obligations, failing which there will be certain heavy penalties. This act talks of penalties for individual violations from around 50 crores to even 250 crores, which can be combined and aggregated for even higher levels of penalties. So there is a heavy deterrence which is there for the data fiduciaries if they don't meet the obligations under this bill. The bill also states that the individuals have certain rights. So on the one hand, there are obligations to the organizations. On the other hand, there are rights to the data principals. These rights have to be protected when personal data is processed by the organizations. That also becomes an obligation. Additionally, the act talks about special care to be taken for children and care to be taken when data has to be transferred out of the country. Plus, of course, it takes special situations where data has to be used by government for law enforcement, so some exemptions will be given. For employees, some exemptions, employee data processing exemptions are given. Startups, some exemptions are given. So the whole act talks about certain obligations, protection of rights, at the same time the exemptions to be given on specific instances, and on the whole expects to discipline the data processing industry.
We are sure about that, sir, and thank you very much for explaining the complete act to us in so less a time. At the same time, let me tell you, we have a great hype generated already for your show, because so many people are so excited to know more about this act from you, and we will be having the questions coming in, I'm sure, very soon. But before that, डॉक्टर धाम, आप एक साइबर एक्सपर्ट हैं, तो अभी जैसे नावी ने एक्सप्लेन किया हमारे को प्रिवेसी के बारे में, डेटा सिक्योरिटी के बारे में, एक क्या फ़र्क होता है एक डेटा प्रिवेसी के बारे में अगर हम बात करें, या डेटा सिक्योरिटी की हम बात करें, दोनों में क्या भेद है?
देखो, डेटा प्रिवेसी है कि डेटा की प्रिवेसी, राइट? आपका जो पर्सनल डेटा है जो कि आपसे बिलोंग करता है, आपका फ़ोन नंबर, इवन आपका रेटिना, आपका जो थंब इम्प्रेशन है, इवन आपके जो मेडिकल रिकॉर्ड्स हैं, वो आपसे रिलेट करते हैं, एनीथिंग विच इज़ पर्सनल टू यू, तो उसके ऊपर जो है डेटा प्रिवेसी एक्ट अप्लाई होता है, राइट? पर जहाँ डेटा प्रोटेक्शन की बात आती है, तो वहाँ पर हम उस डेटा को प्रोटेक्ट कर रहे हैं फ्रॉम हैकर्स। अब इसमें एक क्लॉज है आपके डेटा प्रोटेक्शन एक्ट में, जिससे हम कहते हैं कि कंसेंट। जब भी आपका डेटा कोई भी सर्विस प्रोवाइडर या कोई ऑर्गेनाइजेशन आपका पर्सनल डेटा किसी के साथ शेयर करना जा रही है, अगर आपका फ़ोन नंबर शेयर करने जा रही है, ईमेल शेयर करने जा रही है, तो आपसे उसको कंसेंट लेनी पड़ेगी। लेकिन अगर हैकर आपको हैक कर देता है, अगर उस ऑर्गेनाइजेशन को हैक कर देता है जो आपका डेटा स्टोर कर रही है, तो वो कंसेंट नहीं लेगा। हैकर तो उड़ा के ले जाएगा, आपका इन्फॉर्मेशन चुरा के ले जाएगा, तो वो कभी कंसेंट नहीं लेगा। तो विदाउट कंसेंट आपका डेटा शेयर हो गया पूरी दुनिया के साथ, राइट?
वहाँ डेटा सिक्योरिटी के वजह से,
वहाँ डेटा सिक्योरिटी की जरूरत है, क्योंकि वहाँ उस ऑर्गेनाइजेशन के ऊपर जो है कानूनी कार्रवाई हो सकती है, क्योंकि उसने आपका डेटा शेयर कर दिया, आप उसके थ्रू डेटा शेयर हो गया हैकर से बिना किसी कंसेंट के।
हम एक फोन आ रहा है इसी बीच में, हमारे साथ जुड़ रही हैं रेनू शर्मा। रेनू जी, व्हाट इज योर क्वेश्चन यू वांट टू आस्क नावी?
This Renu Sharma from Hyderabad. I want to know, who does this regulation apply to?
Thank you, Renu Sharma, for your question. Basically, this particular act applies to two types of, you can say, entities. See, on the one dimension, it applies to individuals whose personal data is sought to be protected by disciplining the data processor who collects this data. So you can say this is applicable to individuals. At the same time, the second dimension of this act is, this is applicable to persons, companies, government, and any other entities who actually collect the personal data of individuals and in some way process it. When we say processing of personal data, even collection, storing, and making any changes, they all come under processing. So this act applies both to individuals in the context of protection of their personal data, and to companies in the context of how that personal data has to be protected.
Fantastic. डॉक्टर धाम, जैसे अभी नावी ने एक्सप्लेन किया हमारे को इसके बारे में, एक तो बहुत ही पेचीदा हो जाएगा जब अगर एक कंपनी जो कि डेटा को ले तो रही है अपने पास में, क्योंकि उनकी जॉब ऐसा डिमांड करती है, लेकिन उसको कोई हैकिंग अटेम्प्ट होती है और डेटा चोरी हो जाता है और पब्लिक डोमेन में आ जाता है, तो पेनल्टी तो फिर वो कंपनी भरेगी। उस हैकर की जो एक्ट है उसकी वजह से कंपनी के ऊपर ब्लेम आएगा। तो ये एक बड़ा पेचीदा सा मसला है, इसको कैसे आप समझते हैं हल किया जा सकता है?
इसके लिए जो कंपनी है उसको अपनी एप्लीकेशन को सिक्योर कराना पड़ेगा। तो उस सिक्योर करने के लिए उसको पेनिट्रेशन टेस्टिंग करानी पड़ेगी हमारे जैसे साइबर सिक्योरिटी एक्सपर्ट से। तो उसको हम पेनिट्रेट करते हैं, हम हैकर से पहले हम खुद हैक करके देख लेते हैं कि वो हैकेबल है कि नहीं, और उसमें कितने डोर्स ओपन है जहाँ से हैकर अंदर घुस सकता है, तो कितने उसमें फाइंडिंग्स आ रही है, कितनी लूप होल्स हैं, वो हम निकालते हैं और हम उसको क्लोज करते हैं, और क्लोज करने के बाद दोबारा हम हैक करते हैं, फिर क्लोज करते हैं। तो ये सिलसिला चलता रहता है जब तक वो पूरा हैकिंग बंद नहीं हो जाती। तो ये सिक्योर करने के बाद उनको उस एप्लीकेशन को होस्ट करना चाहिए और यूज़ करना चाहिए।
चलिए, ये बिल के बारे में जो है ये तो साफ हो गया कि डॉक्टर धाम की बहुत सख्त जरूरत पड़ने वाली है आप सभी को। इसी बीच सर एक और कॉल आ रही है कुणाल अग्रवाल की, आइए जल्दी से उनसे भी मिल लेते हैं।
I have a question for you. What are the specific obligations that business will have under this bill? And what are the penalties for non-compliance with the bill? Can you just elaborate about this?
Kunal, actually, the Act expects the category of data processors, whom we call as data fiduciaries, to undertake certain obligations. Data fiduciaries are those organizations which actually determine why they are collecting a personal data, that is called the purpose of collection and processing, and how the data is being processed. So the organization which determines the purpose and means of processing is called the data fiduciary, and any other processor who is like a subcontractor of the data fiduciary, we normally refer to them as a data processor. Now, data fiduciary is expected to obtain what we call as a consent. Consent is a permission to be taken from the data principal. The person who is giving the data is referred to as data principal, and a proper notice has to be given to this particular person in actually 22 languages in India, which are considered as scheduled languages, stating why I am collecting your data, what amount of data I am collecting, how am I processing, how long I will keep it with me, and what are your rights as far as this particular data is concerned. Can you withdraw your consent on a later day? If so, what are the consequences? If there are grievances, how you can approach me for grievance redressal. All these things will be put in a notice format, which sometimes in websites you would have seen privacy policy. That is actually a privacy notice. So after giving this notice, the data principal goes through that and then decides, okay, I can give my data to this particular company because I am in return maybe getting some service or something like that. So I am confident that my personal data will be used by this organization only for the purposes for which they are stating they are collecting the data. So after that, the collection happens, and then the processing has to be done exactly according to what was the purpose. And in case the customer, the data principal asks for withdrawal of the consent or stoppage of the processing, that should be honored as soon as possible. The Act says that the data principals also cannot act funnily by withdrawing their consent. So no consent vapsi is permitted in India. That kind of a situation, the consequences of that will have to be borne by the data principal. That is, if there is an extra cost involved, suppose somebody says, from this moment you stop processing my data, the data fiduciary may not be able to do that, or there may be something of an additional expenditure he may have to incur. So the consequences of withdrawal of consent is on the data principal, and the organization, however, at the end of a reasonable period, they have to stop processing. These are some of the obligations which has to be there, and because of which he has to undertake compliance. I think my friends have been discussing about the data security. Basically, security means, of course, it applies both to personal data as well as non-personal data. There is Information Technology Act, which addresses the consequences of not protecting the non-personal data. As far as the personal data is concerned, if it is not protected, there will be consequences to the organization, that is the data fiduciary. So amongst the obligation, the most important obligation is the security of personal data. If this, you can say this is a compliance requirement. So if compliance is not met by the data fiduciary, there is a series of say penalties. The penalties for not having reasonable security may be 250 crores, up to 250 crores. If a data breach happens, that has to be notified to the Data Protection Board. If it is not, there may be 200 crores kind of say penalty. So in various instances, if there is a children's data, if it is not handled properly, there could be penalties up to 200 crores. Like this, for various issues of non-compliance, the penalties extend up to 250 crores. which can be aggregated and accumulated. One special thing about our law, which is not there in the world, is we expect the data principal to also have a duty. Duty is not to impersonate, give false name, give false information, and make false complaints. If it is done, the data principal also can be penalized up to 10,000 rupees, not in crores, but in 10,000 rupees. Many people are asking why you have to penalize a data principal, whereas the basic objective is to protect him. But even the complainant has to be disciplined, and that is the duty which we expect of all citizens, and that is ingrained in this particular act.
All right. So, डॉक्टर धाम, हमारे को मैंने ये देखा है कि जैसे कन्वर्सेशन आगे चल रही है, एडवोकेट्स को भी जो है बहुत अलर्ट रहने की जरूरत पड़ेगी और बहुत सी चीजें उनको भी जाननी होंगी आपसे। एडवोकेट राशि सूरी हमारे साथ जुड़ रही हैं, जिनका क्वेश्चन मैं लेने वाला हूँ जी।
So there is a provision in the Data Protection Act which basically says that countries to which the data fiduciary can transfer the data will be notified after assessment by the center. My question is that what do you think will be the implications of such a provision, and how do you think this discretionary power will ensure that personal data is not infringed or breached upon by any data fiduciary?
See, one of the most contentious issues of the earlier drafts of data protection law was on this cross-border transfer criteria. What the government has done this time is they have completely avoided the controversy by stating that they will take a decision about countries to which data transfer may be permitted without specific, permission, subsequently through notification. They may have a white list and black list of countries to which data can be transferred. GDPR looks at the white list. We call them as adequacy countries. We may adopt the blacklist approach, saying that these are the 20 countries to which you cannot transfer. Rest of the countries, they will all come under the whitelist kind of a thing. I think that is the approach which the government will do. Right now, there are no specific restrictions on cross-border transfer in the main act.
डॉक्टर धाम, जैसे भी सर ने बताया कि हमारे को जो है वो एक कुछ प्रोविजनिंग इस तरीके से करनी पड़ेगी कि हम लोग अपने आप को पूरा सेफ गार्ड होकर चलें। हर कंपनी को एक सिक्योरिटी मेजर को फॉलो करना पड़ेगा। आप तो माहिर हैं सर, आप तो कंपनीज को बताते हैं कि क्या सिक्योरिटी मेजर्स को फॉलो किया जाना चाहिए, कैसे उनको, तो ये क्या प्रोसेस है? जैसे हम बात करें अगर ISO 27001 की या 27017 की, जो कि डेटा सिक्योरिटीज के ऊपर बहुत ही बड़ा पर्टिकुलर सा एक एक्ट है, तो ये किस तरीके से आप करके देते हैं कंपनी?
ISO 27001 जो स्टैंडर्ड है उसमें जो कंट्रोल्स हैं, अगर कोई कंपनी अपने ऊपर उसको इम्प्लीमेंट कर लेती है तो जितने भी टच पॉइंट्स हैं इंफॉर्मेशन के, उन सबको वो सिक्योर करती है। तो इंफॉर्मेशन कहीं भी हो सकती है ऑर्गेनाइजेशन में, वो इलेक्ट्रॉनिक फॉर्म में भी हो सकती है और फिजिकल फॉर्म में भी हो सकती है। तो वो इतना अच्छा स्टैंडर्ड है, अगर कोई कंपनी उसको अप्लाई कर ले तो इट विल बी सिक्योर्ड फ्रॉम द हैकिंग अटैक्स, वेदर इट इज फ्रॉम द इंटरनेट और फिजिकल अटैक। तो
सर
बहुत ही अच्छा
है। बात करूं कुछ इंडस्ट्रीज की या मैन्युफैक्चरिंग यूनिट्स की, उनको किस तरह की और किस चीज से सिक्योरिटी की जरूरत पड़ सकती है?
जो मैन्युफैक्चरिंग इंडस्ट्रीज हैं उनके लिए इंपॉर्टेंट होता है डिजाइन, जिसको यूज करके वो एक प्रोडक्ट को मैन्युफैक्चर कर रहे हैं। तो अगर वो डिजाइन उनके कॉम्पिटिटर के हाथ में लग गया तो उनको फाइनेंशियल लॉस हो सकता है। तो इसलिए उनको डिजाइन को बहुत ज्यादा सिक्योर रखना पड़ता है उस वक्त जब वो उसकी प्रोडक्शन कर रहे होते हैं। तो उसको प्रोटेक्ट करने के लिए वी हैव टू मेक श्योर कि वी अप्लाई ऑल द साइबर सिक्योरिटी कंप्लायंसेस ओवर देयर इन द ऑर्गेनाइजेशन, चाहे वो आपका साइबर से हो या फिजिकल हो, वो आपका ISO 27001 उसको सबको कवर कर देता है।
डिजाइन एक इंटेलेक्चुअल प्रॉपर्टी है और उसको प्रोटेक्ट करना डेफिनेटली बहुत जरूरी होता है। इसी बीच में एक और कॉल आ रही है, हमारे साथ जुड़ रहे हैं मनीष झा। सो आइए मनीष जी से उनका क्वेश्चन ले लेते हैं।
Myself is CA Manish Jain. From last 2-3 years, I am using the cloud services. As you know, government has passed the Data Protection Act in last 2-3 days back. Regarding that, I have some queries. whether my data is protected under new act or not. If some ransomware attack on the cloud server, whether they can retrieve my data, and most important, can they share my data to third party or any government agencies, because it is the most important in today's scenario. Data is the most important for us. So please share me the answer of these questions.
Manish has got certain questions on the cloud service providers. I would like to say that a cloud service provider becomes a data processor most of the time, and the data fiduciary who uses his service is responsible for the consequences of the storage. So if the cloud service provider is negligent, allows a ransomware attack or something like that, the consequences will have to be borne by the data fiduciary. Now, in practice, what happens, the cloud service provider is a big company like AWS or something. I am a small company, but legally, I am still the data fiduciary and the cloud service provider is my servant. So there has to be a contract in which he has to do what I tell him. Otherwise, he should be considered as a joint data fiduciary. In most of the cases where the cloud service provider or an application provider does things without taking my specific permission, but I accept that service because I consider him as good for that service, then he will become a joint data fiduciary. So this act tries to provide responsibility to cloud service providers as data processors or at least as joint data fiduciaries. We have to actually ensure that our contract is properly drawn.
Now there is so much to ask in every answer that you're giving to us, but then the questions are, the calls are just flowing in, And now we have Mr. Ravinder Singh who wants to ask you something.
Hi, I am Ravinder Singh from CyberNet Solutions. My question is, how will the bill impact to use of artificial intelligence and machine learning in India? Second, how will the bill impact to growth of the digital economy in India?
AI is an action of a software, and our Information Technology Act clearly says that activity of an automated software is attributed to the owner of that software. So whether it is artificial intelligence or machine learning, it is considered as the activity of the individual who is the owner of the artificial intelligence. So he becomes the data fiduciary, and accordingly the law will be applied on the owner of that artificial intelligence software. Again here, if I just pick up some artificial intelligence software without knowing what it does, then you have to have a contract in which the AI supplier, if he's a software service provider, he should be considered as a joint data fiduciary. Otherwise, I will be taking responsibility for something which I don't know. That is something which the companies should avoid.
Now there is another caller on the line. Let's take him also, Mr. Nitin Mittal. Please ask your question, sir.
Hello, Dr. Dham. Hello, Raishi. I am Nitin Mittal from Eminence Media Private Limited. As per the new regulations, we have to take consent from the clients before sharing his personal details with anyone. I want to know that how will this impact CRM applications and business applications which hold client details, and what changes they have to make in their application.
Here also, just like I earlier said, the application providers, if they want to remain in the background, then they will be taking on the role of either the data processor or as a joint data fiduciary. If they don't share the code to the other person, and if they don't disclose how the software works, then they will be called joint data fiduciaries. They will have to take the responsibilities. So CRM providers or any other people, if they have already collected the data, this law says that you have to take a fresh consent. You have to send out request for fresh consent, but the law says that when the fresh consent request is made, the data principal, if he remains silent, then you can consider it as deemed consent and continue the processing.
Naavi, mails are considered to be a legal tool now. Mails are accepted as a legal tool. So if we have sent a mail across to the client that these are the new bylaws or these are the new laws, and if the mail has not been replied to, will that be considered as an information which has been passed on?
It's a great question. You have to have some kind of an evidence that the email was sent from your end. So, in fact, that has to satisfy the Indian Evidence Act. Presently, we have got something called Section 65B, and the government is now introducing a new version that will be having Section 63, which has got similar provisions. So a company need to have a record that it has sent a request for continuation of processing to the person, and then document that this has not been, of course, we cannot document that it has not been received, but at least they can document that they have sent it. So that is a new compliance requirement which they may have to do. This kind of a service has been introduced by me long time back. Under this, we have actually sent court notices through email supported by Section 65B certificate that we have sent it to.
Naavi, we have reached the end of the program now, and but we still have one more caller waiting in the queue. So let's take him also. He's Mr. Hemant Gupta. Let's see what he has to ask.
Namaskar Rajesh ji. Good evening, Dr. Dham. My name is C. Hemant Gupta, and my specific question with regard to this data protection bill is that having a law is one thing, and its implementation in two spirit is another thing. How do you think in a country like India, this data protection bill will be implemented and implemented successfully? What is going to be the most challenging thing to implement this law in India?
Implementation of a law is always a challenge, and that makes the difference of how effective the law is. So I hope it will happen because of one, there is a huge deterrence. Secondly, the law is as simple as it could be. It is not as complicated as GDPR. And people like us who are working in this area, we are trying to make it even simpler by developing appropriate frameworks. I have developed something called Personal Data Protection Compliance Standard of India, and FDPP is using that for our audits. So people have to use such methodologies to ensure that they remain in compliance. We should not take on the government about what will happen if I don't comply kind of a thing. So a culture of compliance need to be spread across the country, and then the implementation challenges will actually die down. The government has got 250 crores and other deterrents, but I am sure they would not like to use it against our friendly industry people. So the public also, public in the sense the industry has to respond positively, then perhaps these implementation challenges can be suitably addressed.
Wonderful, Naavi. It was a wonderful session. I mean, it was a marathon, I should say, because so many calls had come, and you were so prompt in your answers. Thank you again for being here with us and giving us such valuable inputs on the bill. जिससे पहले कि डॉक्टर धाम मैं इस शो को जो है अंत करूं, मैं आपसे ये जानना चाहता हूं कि कंप्लायंसेस की नावी ने अभी बात करी, तो जो कंप्लायंस की नावी बात कर रहे हैं उसकी इम्प्लीमेंटेशन आपके हाथों में है, तो किस तरीके से आप इंश्योर करते हैं और क्या कहना चाहेंगे आप पब्लिक को इस समय?
इसमें क्या है कि हर कंप्लायंस के लिए एक ISO स्टैंडर्ड बना हुआ है. क्वालिटी के लिए ISO 9001 है, इंफॉर्मेशन सिक्योरिटी के लिए 27001 है, पर इस डेटा प्रोटेक्शन बिल के लिए अभी कोई कंप्लायंस ISO कंप्लायंस नहीं बना, बट वो हमने बनाया है, जो कि नावी जी ने FDPPI ने बनाया है, जो कि डेटा प्रोटेक्शन कंप्लायंस स्टैंडर्ड है. वो अगर वो स्टैंडर्ड हम इम्प्लीमेंट कर दें कंपनीज के ऊपर, तो वो पूरी कंप्लायंट हो जाती है, और हमारी कंपनी GISPL FDPPI के साथ मिलके इसको पूरी दुनिया में फैलाना चाह रही है, तो ताकि लोग इसे इस कंप्लायंस को अपने यहाँ इम्प्लीमेंट करें, और एक ही कंप्लायंस को इम्प्लीमेंट करने से वो सारे जो कि लॉ एक्ट के अंदर जितने भी क्लॉजेज हैं उनको कंप्लाई कर जाएंगे ऑटोमेटिकली. सो दिस इज व्हाट वी हैव डन. एंड
ब्रिलियंट. Naavi, thank you again for being here with us, and Dr. Dham, thank you, आप अपने समय निकाला. और मैं अपने दर्शकों को बोलना चाहूँगा कि अगर कंप्लायंसेस जो हैं अगर आप करवा लें अपनी डेटा की सिक्योरिटी के लिए, तो आपका जो डेटा है वो तो सिक्योर रहेगा ही रहेगा, लेकिन आप ये याद रखें आपका डेटा ही आपका पैसा भी है. जी, अगर डेटा सेफ है तो आपका पैसा भी सेफ है, आपकी मार्केट भी सेफ है, आपका बिजनेस भी सेफ है। इसको बनाए रखने के लिए यदि आपको नंबर्स की आवश्यकता है, यहां नंबर्स दिए जा रहे हैं। डॉक्टर धाम से आप जुड़ सकते हैं, नावी से आप बात कर सकते हैं, मुझसे आप मिल सकते हैं। तो इसी सिलसिले को जारी रखेंगे हम अगले शो के अंदर भी। कुछ ऐसी इंटरेस्टिंग पर्सनालिटीज को आपसे मुखातिब कराता रहूंगा टेक टॉक्स के अगले एपिसोड में। तब तक के लिए थैंक यू।